सो नेक्स्ट गुड मॉर्निंग एवरीवन। अब हम नेक्स्ट टॉपिक से स्टार्ट करते हैं। द नेक्स्ट टॉपिक इज ऑर्डर वन एंड इसमें हम डील करेंगे जॉइंडर, मिस जॉइंडर ऑफ पार्टीज, व्हाट इज नेसेसरी पार्टी एंड व्हाट इज प्रॉपर पार्टी। तो बेसिकली आपका ऑर्डर वन जो है वो डील करता है कि पार्टीज टू द सूट कौन होती हैं, और आप अगर किसी इफ यू आर सीकिंग रेमेडी अगेंस्ट a civil action basically against any person, you need to be sure you are making all the necessary and important parties that are there against you, and you're making them a party in as a plaintiff or a defendant, as a co-plaintiff or a defendant, because then only you can ensure that you will have an effective remedy. Because after all the due process of due civil process, going through the entire process of trial, examination, witnesses and everything, you will get a decree in your if you get a decree in your favor, then you need to be sure enough that it would be enforced in the court of law properly. It would be only enforced if the other party would be given a just, fair and reasonable chance to defend the case, and he and that can only be there so if they were also made the party to the suit. That's why order 1 says who can be joined as a plaintiff. It says all persons which have a right to relief, like all persons may, because it's a discretionary provision, right to, who has a right to relief from the same act or transaction or a series of act of transactions. The person who has, because for relief, it is right to relief, that is they have the same cause of action, that is there is a right, and that right is denied to them by a same act or a transaction, then they could be joined as plaintiff as per order 1. They can have joint interest, several interest, or alternative interest. If they have joint interest, they can file the suit together. Example, they can be a necessary party or a co-partners. They are suing a property. There is a trespass to a property which is owned by two persons, A and B. Then both the persons can have a joint interest in the property, and therefore they both have a right cause of action against the wrongdoer, and they can very well bring an action of against the trespasser jointly. There can be a several interests also. For example, a property has already been, there is already a partition in a joint Hindu family property, then the individual share owners can bring the suit, or they together can bring the suit also. Then a person can have alternative interest also, they can also jointly bring a suit. For example, there is a wife and there is a son of the father. Then there is he he is that father's son, may he be adopted son. There is FS, and the deponent, the deceased, there is a deceased brother, a father's brother, FB. FS says that I can prove that I am the adopted son. Both wife and and FS will get 50% of the property according to the Hindu Succession Act. Otherwise, if he is not able to prove, W will inherit the entire property, and the property is currently with the husband's brother और FB father's brother, basically चाचा ताऊ के पास में है property. So now there is an alternative interest between the mother and the son. So they can together file a claim against FB. And there is also another pointer that is there, which is order 1 rule order 1 rule 1 ka subclause B, which says if a separate suit is filed, then the common question or law of fact would arise. There will be same questions that are there. So if they are dealt in a single suit, it would be better. So that could be, then those plaintiffs can together bring a suit. There is also can be a case, now we are aware who can be joined together as plaintiffs. Similar is the issue with the defendants who can be joined as who may be joined as defendants, that is provided under order 1 rule 3. Similar, if this common question of law and fact may arise, then they can be joined as defendants. In short, basically, if we deal with it. But if then there are two types of parties. There is a necessary party and there is a proper party. There is a necessary party is a party that is essential to join in a suit. If it is not joined, then a suit can not be effectively and comprehensively be decided, as that necessary party who was not joined in the earlier suit may raise an objection or an obstruction at the stage of execution that they were not given a fair chance to put forward their case because they were not made a party to that suit and they were not aware of the proceedings, and therefore there is a violation of their right to natural justice. We have audi ultram partem and the right of audi ultram partem is being violated. However, the decree so passed will be valid, but they can create an obstruction or objection at the time of execution. For example, joint owners, co-partners, partners, beneficiary interest. Because somebody, like suppose A and B are joint owners of a property and B has filed a suit against any person, and suppose B loses, then the entire property is lost. But A was not aware about it. A should also be made a party to it. Necessary parties are those who have jointness of interest. For example, in a suit of partition, all sharers that are to be granted shares are necessary party. But if a karta is filed the suit, then karta is basically a agent for the entire all the co-partners. Therefore, joining of all the co-partners in the suit is not required, and therefore, the same co-partners will not be a necessary party, and their joinder will be a mere formality. We can also explain necessary parties in the term that if the matter and issue between the parties are completely or substantially overlapping, then in the suit they will be called as necessary parties. The matter and issue between the parties are completely and substantially overlapping, then also they can be called as a necessary party. At the same time, we can understand what is proper party. In the cases of proper party, it is not necessary to join them either as a plaintiff or the defendant, because we have seen order 1 rule 1 joining of as a plaintiff, order 1 rule 3 joining as defendants. This is not required. Joinder of proper party leads to a comprehensive decision in a suit. It is considered better For example, if you can see this example here, A is the owner of the third floor and B is the owner of the ground floor, and there is an issue regarding passage. So the people living in the first floor, second floor, they are all proper party. Third floor person is seeking passage from the person who is acquiring the ground floor, but the passage is also there for the first floor people and the second floor people. Therefore, there will be a proper party. Here, there is no joint. Similar, you can also reverse as there is no jointness of interest. Matter and issue between the parties are not completely and substantially overlapping. You can take in another example that is there in a suit for possession of landlord against his tenant. Subtenant is a proper party. Subtenant can be a proper party in a suit if only that's this thing we have written again in like in negative terms, because that matter and issue is not substantially or completely overlapping, partially overlapping, we can say, then they can be considered as a proper party. So we have seen if there is a necessary party and he is not joined, he could have raised objection at the stage of execution. So that is dealt under section 47. 47 says all questions arising between the parties relating to the discharge, execution, and satisfaction shall be determined by the executing court. So no second suit can be filed if there can be a decree. If there are objections, will be decided by the executing court only. And their objection can be there that was not made a party to the suit. That's why, regarding the satisfaction of the decree, it is on the ground of non-implement of necessary party, the court can refuse execution on application by the necessary party. And at the appellate stage also, if there is an appeal, then the appellate court can set aside the decree and remand the case for impleadment under Order 1 Rule 10. Similarly, we have to see section 99, which says no decree reversed, varied, or remanded in appeal on account of misjoinder or non-joinder of property parties. But if there is non-joinder of necessary party, the decree will be set aside. For other cases, the test will be whether it affects the merits of the case or not. But in the case of necessary party, it will not be so. The decree will be set aside, and it is not necessary to examine the failure of justice. So that's why it is very important to ensure that we have filed a comprehensive suit and made necessary parties part of the entire suit. Then we have another terms that are there, that is misjoinder and non-joinder of parties. Misjoinder, we had to join somebody else and we joined somebody else as a plaintiff or a defendant. For example, that there are two conditions: that the cause of action by the same act or transaction and the interest could be joint, severable, or alternative. And the second condition is that there will be common question of law or fact. These conditions are not joint, but the parties are joint, and that is, they are made parties to the suit. Then this is the case of misjoinder or wrongful joinder. We can In simple words, we can say a person joined as a plaintiff or defendant who is neither a necessary or proper party. This is the case of a non-joinder. These are parties unnecessarily joined to complicate the trial. Here, Order 1, Rule 10 can be used to strike out unnecessary parties. That is, the person is joined and the conditions of Order 1, Rule 1 are not met. Then this will be the case of misjoinder of the parties. There will be no effect on this on the suit. Then at the same time we have other topic, that is non-joinder of the parties. There is a party that is very important for the suit and he or she is not joined, which we have already dealt in. What will be the scenario of this? That is, there is a necessary party. So let's end it here, and the other sections will deal with the next video. Thank you.